only mode.
Hi, good morning. Welcome to our webinar, Structuring Independent Contractor Arrangements for Architecture, Design, and Engineering Firms. I'm Mary Ann Blau, an HR consultant with Shared HR. We're on a tight schedule this morning and we want to be respectful of your time. Because of this, all attendees have been muted. If at any point during the webinar, if you have a question, there is a questions box in the GoToWebinar control panel. You can just type your questions in there. We will be answering them at the end of the webinar. If we run out of time and are not able to get to all of the questions, we will get back to you privately after the webinar has concluded. Additionally, when you exit the webinar this morning, a survey will pop up and we would really appreciate your candid feedback. So I'd like to go ahead and introduce our speakers for this morning. Paul Finkel is president and founder of Shared HR. Paul has consulted in HR and labor matters for over 30 years, has structured over 100 independent contractor relationships, and assisted employers in state and federal contractor audits. Eli Gould is a senior employment attorney with MBV Law. Eli provides a full range of legal services on employment and labor issues, confronting employers and managers, including preventative training on legal pitfalls confronting employers in California and advice on wage and hour and employee classification issues. And now I'll go ahead and turn things over to Paul and Eli. Paul, are you there?
Yes.
You cut out on me, Marianne.
Yes, we all kind of cut out for a moment. So why don't I good morning, everyone. The agenda and the way we'll handle the webinar today is to talk about an introduction at first and talk a little bit about what the issues are, define independent contractor relationships versus employment relationships, then talk about why contractors are in the crosshairs, why Eli and I believe that there will be more contractor audits and that these contractor relationships are going to face more scrutiny than ever before. Eli will go through the legal considerations and developments. There have been some fairly recently. And then there will be the practical considerations of dealing with audits and how you properly structure agreements. As Marianne mentioned at the end, we will handle questions. We'll handle all that we can live, and then we'll get back to anyone who has additional questions. So with that, let me introduce briefly Shared HR. We're an HR consulting and technology firm. Our model is to share best practices and processes which we developed over 30 years. Our cloud computing or SaaS model provides us a way to translate the HR data overload into some sort of usable actions for employers. And it also provides us a way to simultaneously update multi-state compliance for our clients on the platform. This webinar is part of our continuing effort to make sense of the employment-related legislative, regulatory, and legal changes out there. Our goal is to give employers a window into the trends that we see in some direction on how to attract, develop, and retain the best talent while avoiding employment litigation. Marianne already introduced me, so with that I'll turn it over to Eli to introduce his firm.
Good morning, everyone. The slide kind of gives you the information about our firm. We are a full-service firm. We do virtually everything on the legal arena. I am an employment lawyer and have been for my entire legal career, which now extends for 25 years. And I've been with MBV Law for the past 9 years. MBV has a special penetration into the architecture, engineering, and design industry. We represent a number of firms from very small to international sized firms. Bill Mandel, who is one of the founders of the firm, is a recognized expert in the area of ownership transition in personal services industries and represents personally several hundred architecture, engineering, and design firms. I have worked extensively with them for the 9 years that I have been here and have learned quite a bit about the industry and quite a bit about the pitfalls that can befall the industry when it ventures into working with independent contractors or trying to establish independent contractor relationships.
Great. So with that, let's jump right into some definitions. There are two basic types of personal service providers. And that really is employees, which we know about, but basically that would mean someone directly employed by your organization or through some sort of a agency or broker or leaser that employs the individual, but the primary relationship would be an employment relationship between some employer and the individual, and they get a W-2 at the end of the year. And the next group would be independent contractors, and there can be many flavors of contractors. Subcontractor and consultant are a couple that might be familiar.
I want to emphasize, not to interrupt you, Paul, I want to emphasize something that people don't realize is that legally there are only those two types of people providing personal services. Sometimes people think that there can be different flavors, but it really is pretty black and white when it comes from a legal perspective as to that there are only two possible types of people who provide personal services. And that's important to keep in mind because the kind of presumption on the part of a number of agencies is that if someone is providing personal services, you've got an employee. And they will look at all kinds of relationships to determine whether it falls into one bucket or another.
Good. And we'll be going into that in more detail in a few minutes, but thanks for that clarification, Eli. So here's some of the recent news articles that have come out. This recent case actually is an important one that makes contractors come into the crosshairs, and it's a 2011 case. And in this particular case, the Court of Appeals overturned a summary judgment ruling at the trial level. So, in other words, the engaging entity won at the trial level on a summary judgment saying that there was no showing that the individual truck drivers in this case were in fact employees. So it supported the employer's contention that they were independent contractors. And the Court of Appeals overturned that ruling and said, no, the basis for that ruling was only one factor, the right of control. And we're not going to agree that only one factor is dispositive in determining whether there's a contractor or employment relationship. And this is a very important case because oftentimes people think, well, if I don't have the right of control, if the individual really decides when they're going to come to work and what route they're going to take and what tools they're going to use, then they're really not an employee. And this case pretty clearly found that that factor alone is not enough.
Yeah, this is an important case because it emphasizes what a number of courts have been acknowledging both on the state and the federal level. It used to be the case that you had kind of a single monolithic test as to whether or not someone was an employee or an independent contractor. And you could go through that test and feel relatively confident that if you passed it, that you would survive an audit or at court. It's clear now that the tests that are out there are being kind of melded together, if you will. And it's a much more complex and difficult process to be comfortable that you, in fact, have an independent contractor as opposed to an employee.
And there's some more factors that now make us think that there are government agencies that are really going to start focusing on contractors, or as often called misclassified workers. And this is the view of many agencies that might look over your shoulder and try to disrupt these relationships or analyze these relationships. The predominant view is that If you got people providing services, they're employees. Now prove they're not. So the Obama administration last year estimated there's a $7 billion number out there in additional taxes that can be collected from these misclassified workers. And with our federal government, state government, and local governments in the financial straits they're in, there is a renewed interest in collecting taxes on, quote, misclassified workers.
Yeah, there are so many agencies out there that have an interest in this issue, both state, federal, and in the case of San Francisco, local. For example, we have a payroll tax here, and the city of San Francisco is very interested in collecting the payroll tax in every appropriate circumstance. There are a variety of state agencies, the Department of Labor Standards and Enforcement, the Employment and Development Department, which collects and administers unemployment insurance, state disability insurance, and paid family leave insurance, this state franchise tax board, and the federal government, and the Department of Labor and the IRS. So there are lots of interested entities out there looking to make sure that you are doing this properly.
Here's just a couple of other factors. That there was a big case against FedEx, which is being litigated now still in 19 states over their local drivers as being employees as opposed to contractors. And this has been kind of a sleeper issue for a few years, but now, as we were talking about earlier, with the increased interest in collecting taxes, we believe that this contractor area is going to become a very hot issue.
Definitely.
The Department of Labor is another example. They've come out, and this is a direct quote from them, that in 2012, the department's preparing for this, they will continue to protect workers and level the playing field for businesses by investing $50 million to combat worker misclassification, particularly in the wage and hour division. The OFCC, the Occupational Safety and Health Administration, Office of the Solicitor, Employment and Training Administration. These are agencies that are all under the DOL, but you don't hear about very often, but I think you're going to start hearing about more, particularly for those who are federal contractors. And they're saying that when workers are misclassified as independent contractors, they are deprived of benefits and protections to which they are legally entitled, and law-abiding businesses are placed at a disadvantage against employers who violate the law. That's a direct quote.
That last point is something to keep in mind, particularly under California law. And we'll get to it a little bit later, but it opens up or has opened up a whole new area of litigation here in California that is very troublesome for employers.
So W-2 employees are clearly the safest. That's what all these agencies want you to have. Why? Because the eagle basically can have its talons in the prey more easily. In other words, pardon the crass analogy, but basically it's about collecting taxes. And it's very easy to do payroll tax audits, and there is almost 100% compliance with payroll taxes and the collection of taxes when someone's getting a W-2. That's why they want everybody in that category. They know that all the federal and state taxes are properly withheld. They come right off the top, and there's severe employer penalties for not making those withholdings and payments. So that's why it becomes your burden to prove otherwise if someone, if you're trying to claim someone is actually a contractor. So Eli, why don't you take it from here?
Sure. I want to talk a little bit about the various tests that are used by the various agencies. And one thing that is very, very vexing for employers is that different agencies do use different tests. We're starting to see more homogenization among the agencies, but that just means that the tests are kind of getting lumped together, which, as I said, makes it more difficult for the employer to be confident that they've actually satisfied. the test. The basic tests that have been out there for a long time, first is what's called the IRS 20-factor test. That's also sometimes known as the Common Law Control Test, and I'll get to that in a little bit more detail. An emerging test is one that has kind of come out of the Department of Labor and that has been adopted by a number or an increasing number of courts. That's called the Economic Realities Test, and that developed under the Fair Labor Standards Act to determine when you had someone who needed to be paid the minimum wage, needed to be paid overtime, and have compliance with the rest of the FLSA. There also is what's called a common law test of master and service that has been adopted by a number of agencies and within a number of statutes, including the Americans with Discrimination Act, the Age Discrimination and Employment Act, and determining who is an employee for purposes of ERISA welfare and benefit plans. The California Division of Labor Standards Enforcement, which basically looks at enforcing California's wage standards, has also developed its own tests, which is a permutation of the IRS 20-factor test, but it doesn't track it directly. One thing to keep in mind that is often surprising to my clients is you can have a situation where two entities are found to be the employer of an individual. Some clients think if they've got someone who is working for them, providing services, but is employed and is a W-2 employee of someone else, that they're safe, that this person will not be found to be their employees. That's not the case. There are a number of instances where both entities can be found to be the employer and both liable on a number of different theories. Typically it comes up under discrimination or under like the FedEx case that Paul referred to, where that came up under California's Labor Code Section 2802, which is a statute that requires an employer to indemnify its employees for all costs incurred in the course and scope of their employment.
Should we do this next one?
Yeah. The IRS control test is basically focused on the idea of who controls the means and methods by which a service gets provided. Typically, an employee is someone who is brought in, provided the resources, trained in some instances, and is told that this is what we want you to do and this is how we want you to do it. Conversely, an independent contractor is someone who has tools, skills, expertise that you don't find in-house. And you go to that person and you say, I want this. I want it by this time. There may be some milestones in there for assessing progress. And I want the right to say at the end, this is to my satisfaction. And then the independent contractor goes out and does whatever he's going to do at his own time schedule, keeping in mind that he needs to meet your milestones. And at the end of the project or the period that he's doing this, gives you that product, that thing, and you assess whether or not you're satisfied with it and pay for it. And that is kind of the focus of the IRS test, and that is the oldest and the most traditional test, and that's the one that most employers know. But that, as I've said a couple of times, is not the only test, particularly here in California, nor is it necessarily the favored test.
So if we talk about, the economic realities test, for example, that one, which is relied upon heavily in California, talks about not only control, but what are the economics? Are there things like the duties, are they integral to the employer's normal business, or are these some special duties that the company can't normally pay? Is there an investment by the contractor in the business? How long is the relationship? Is it permanent, or is it just to perform a particular task and go away? Is there really opportunity for profit and loss? These are really important questions that need to be answered in California if you're going to pass the test. The other threshold item that I've run across, Eli, is that in California, and this is not true always with the IRS, there absolutely has to be a written contractor agreement. And if that's not in place, it's a total non-starter. You've lost.
Yeah. This is what I like to call the if it walks like a duck, quacks like a duck, you got a duck test. And they approach it from kind of two paradigms. One is with an employee, they come to work, they do what you tell them to do, they get paid. If they don't do it right, you can discipline them, you can fire them, but they basically have no risk at all as long as they do what you tell them to do. Paradigmatically, on the other side is the independent contractor who is out there, has his or her own business, has to have some investment in that, and how much profit they make really depends upon how well they run their business. So there is risk associated with being an independent contractor. And if you've got a situation where there is no risk being borne by the person you're calling an independent contractor, then under this test you are almost certainly going to fail. The couple of other tests that are in the slide, I don't want to go over them in too much detail. The next one is what I refer to as the common law test of master and servant. This is something that is still out there. It factors into the assessment by a number of agencies, but I'm finding that it is kind of waning as the test to look at. Though there is a recent California case that held that under the common law test, a group of people who were promoters for a farm who employed migrant labor people was not an employer under the common law test of master and servant. It's an important decision, but it yields very little comfort for a lot of employers who are engaging independent contractors. In 2010 as well, the Ninth Circuit, which covers California, basically said all of these tests are the same test, and that all of them have to be looked at in determining whether or not someone is an employee or an independent contractor. It may sound like we're doomsayers and trying to scare you, but there are a lot of risks out there if you do not properly classify people as independent contractors or employees. There is the payment of payroll taxes and penalties for not paying that, risk that you have not appropriately provided workers' compensation for these people. And in fact, if they are employees and you haven't provided workers' compensation, you're probably going to be liable for a whole lot more in damages than if you did cover them under workers' compensation. State disability and paid family leave insurance contributions, unemployment insurance. There's liability for employee benefits. A seminal case in this area is one that was brought against Microsoft about 8 years ago now, in which a group of people who had signed agreements that they were independent contractors of Microsoft sued in order to become eligible to participate in their employee benefits plans. And even though they had agreed that they were independent contractors and were not eligible for benefits, they were found to be common law employees and therefore covered under the benefits plan. Penalties and interest, employment law liability. You've got someone who you don't think is your employee, but sexually harasses one of your employees, and it turns out that they are your employee and you're therefore liable for their conduct. Here in California, an interesting development that has come up within the last 10 years or so is the courts have found that an employer who does not properly classify their people as employees as opposed to independent contractors, and who isn't paying what they would pay for the employees, is at a competitive advantage against others, an unfair competitive advantage. And you can therefore bring an unfair trade practice lawsuit against that entity, claiming that by violating the law, they have violated the Unfair Trade Practices Act. And that can be brought in individual capacity. It can also be brought under California's Private Attorney General Act on the behalf of other people. So I am seeing in virtually every lawsuit that alleges that there is a wage and hour violation and that someone has been misclassified as an independent contractor, you're seeing an unfair trade practice claim in there, and you're seeing a Private Attorney General Act claim in there.
Mm-hmm. So let's talk about some practical considerations about what you can do. One thing that we recommend you do is do a risk assessment, and think about when you're going to make a decision between a contractor and an employee, how important are these contract relationships really to the business? Are they integral to the business, or is it for a specific project? The more integral it is to the business, the more likely it's going to be an employee. In that seminal case called Visconio versus Microsoft that Eli was just referring to, these people were contract programmers, and they were sitting right next to employees doing substantially the same thing, only under a contract. And that was one of the key factors that caused those relationships to be disrupted. Next is, how sophisticated are my contractors? In every one of the audits I've been involved in, the auditing entity, regardless of the agency, always interviews the contractors. And if they can articulate their independence, if they sound like an independent business person, if they have business cards, it's this sort of walk and talk like a duck that Eli's referring to. If they can, if they're sophisticated enough to pull that off, then that's going to be believable. If they're not, why are you a contractor? Well, that's the only way they'd engage me. That is probably not going to fly. Is there a common industry practice? There are some industries, such as trucking, for example, where there is a very common practice of engaging independent contractors for over-the-road drivers. But as we saw in the FedEx case, when it gets to local drivers, it's a horse of a different color. So that is probably not going to be particularly protective in this industry. And then, how would we successfully and could we successfully defend our practices and systems if audited? You have to ask yourself those kinds of questions.
When I am working with clients on trying to figure out if they can establish a true independent contractor, I have a list of questions that I take them through, and then this is a shortened version of this. It basically is, why do you want to use a contractor instead of an employee? If the answer is because I don't want to pay FICA or I want to keep my costs down, then that probably is not going to be a good enough reason to do it, because that's exactly what the IRS and these other agencies are looking for. Another question I ask is, who is dictating that it's going to be an independent contractor relationship? A number of my clients find themselves in the dilemma of looking to bring people in to provide services, and that person doesn't want to be an employee, doesn't want withholding, doesn't want the other deductions that are made. They want to be 1099 at the end of the year and then deal with taxes themselves. Again, that probably isn't a good enough reason to set it up as an independent contractor relationship. The point that Paul made earlier, if you've got someone who is doing exactly what you do, your employees do, then it's very unlikely that that person is going to be found to be an independent contractor. It's more staff augmentation. For example, if you've got some spikes in your work and you're bringing additional people in, and staff augmentation is not an appropriate use for independent contractors. Ask yourself also, is this the optimal arrangement or the only possible arrangement? Are there other things that could be done, such as bringing on temporary employees, going to a leasing company or a temp agency to bring in people? And then the final one, and I think it is something that clients often miss, is the fact that historically this has been done and other people are doing it, a good enough reason to keep doing it. That has bitten so many employers. For example, the FedEx case, everybody structures their relationships the way FedEx did, everybody in that industry. Well, they're now changing it because FedEx has scared them to death, and it ought to.
So on the audit side for just a moment, and there's a list of questions that you can conduct yourself, a mini audit that we're providing with this webinar, and at the end you can simply request a little survey and we'll be happy to email that to you. But I'd like to share a little bit from my war stories about how these audits normally start. Frequently, it's a disgruntled contractor. On the front end, like Eli was saying, people come to you and say, well, you know, I want to be 1099 at the end. I don't know how much work I'm going to get this year. My work's kind of sporadic, so let's just 1099. It's only going to be for a few months. And then the project ends as agreed, and what do you know? They can't get more work, so they come back to you and they file for unemployment insurance. Or they say, well, I was always an employee, even though they may have signed an agreement that says otherwise. In a recent audit, in fact, this one I have going right now, this is exactly what happened. The person was an employee of the employer, then entered into a contractor relationship. The work ended as predicted, and the individual went and filed for unemployment insurance. And the EDD's response was, well, we believe the worker because no one in their right mind would ever leave a W-2 situation to enter into a 1099 situation. And that is the prevailing thought of the people that do these audits. What happens in that scenario is that your former contractor is now sitting on the other side of the table next to the auditor, telling that person where all the bones were buried because it's now in their interest to have been an employee and not a contractor. And that is not a fun scenario and one I've been through many times. So that's why it's safer for both sides to make sure that these factors are actually in place. The next one is with the improvement in technology, the IRS can do an electronic search for high 1099s associated with an employer tax ID number. So it's pretty simple to see these large 1099s. And then the question is immediately raised to them, okay, if there's large 1099s, what's going on here? Maybe there's misclassified workers. A workers' comp or an unemployment insurance claim. Someone gets hurt on the job, and as Eli said, this is really a double-edged sword. If somebody gets injured, and it's not always a slip and fall or a back, it might be a psychological injury that we're seeing more of these days due to stress or other kinds of problems. If you've treated them as a contractor, now you don't have the protection of workers' compensation, which means that they can come after you for tort liability, and you don't have the remedy or the exclusive protection of workers' comp.
Yeah.
On the other hand, if the average person doesn't think about that and they just want coverage for their medical, and they were a contractor, sometimes they'll file a workers' comp injury or claim just to get coverage. So it's kind of a lose-lose situation for the engaging entity. There are some industries that have been singled out by these administrative agencies for particular scrutiny. And you don't know when that's happening to your industry. And then the other way we've seen it is as part of a financial audit or other type of an audit, they rope in the contractor or misclassified worker piece. So these are the most common ways in my practice that I'm seeing these kinds of audits develop.
Yeah, one of the most aggressive agencies here in California conducting these audits is the Employment Development Department. And that often comes about as a result of someone filing an unemployment insurance claim. But they are a wedge agency. Once they're in your door, there are a lot that will be following right behind them. And they are very aggressive here in California. I sometimes
they are.
And
I've got some recent cases like that, that I've worked on. One in particular where the disgruntled contractor sought to withdraw his claim for unemployment insurance after talking to the engaging entity, and the EDD said, "Thanks very much, but we're going to audit anyway."
Yeah,
so that was a really troublesome situation.
They've been very aggressive about taking the position that this is something that is being done for the public good and not necessarily the benefit of individual employees / independent contractors.
Another point that I'll bring up is if, let's say you had a contractor and that individual filed an unemployment insurance claim, and the EDD rules against you as the engaging entity and says, no, we think you are an employer, I would strongly encourage you to appeal that ruling and don't just let it sit, because that's going to be a very bad fact if there are future audits or if the case goes any further. Because they're, the view of these agencies is, well, if you really believe that, why didn't you appeal? Why didn't you vigorously pursue that? Next, here are some basic steps. So I guess one of the recommendations we are making in this webinar is that you audit your existing relationships and think very carefully about getting into future ones. But here are some key factors that should be present when you're auditing your existing relationships. Written agreements, as I mentioned earlier, it is a non-starter in California if you don't have some kind of a written agreement. And that written agreement really ought to be pretty clear about the fact that what role is each party playing, how it's separate, it's not to be considered employees, employment under any circumstances. Vendor invoicing and treatment. This is another huge problem I find in the audits I've been involved in. Employees get paid on payroll. Contractors submit invoices. There have to be some invoices, and it should, be the name of the business that's billing you. So if you are engaging Joe Jones, and worse yet, if Joe Jones was once your employee, you certainly would like it to be Joe's maintenance or Joe's landscape architecture or whatever the engaging entity is going to be, service the person is going to be performing, not the individual's name. And there should be invoices coming from that business entity. And there should be other indicia of that business relationship, like maybe a website, a business card, a business bank account. All these sorts of things are very important indicia when you're trying to establish that Joe's landscape architecture is actually a standalone, arm's-length business entity and not an individual who is between jobs and who's doing this work on a 1099.
Right. Because
that's the presumption that they're going to make when they come in, that you're trying to play hide the pea as to where the problems are. And they're going to be looking for examples of other clients of Joe's landscape architecture, alternate streams of income, separate tax filing. Is the other business actually incorporated? That's a really important one, because if the other business, if the landscape architecture firm isn't incorporated, oftentimes, in fact, in every audit that I've been involved in, they put all those questionable relationships to the side and they immediately call them contractor relationships. Why? Because if the individual has gone to the trouble of actually incorporating and they pay their minimum taxes, then that is a very clear indication that it's a standalone business. Also, they're not subject to a 1099 audit because if they're incorporated, they're a corporate vendor, and as of right now, you're not required to send them a 1099.
Right.
So those are really important distinctions that you would like to be able to show with any entity that you're engaging as a contractor. That's a lot easier for me to say than for you to do, but those are ideal scenarios where you have those kinds of crystal clear distinctions. Are there any other indicia that you can see, Eli, that you might want to throw in at this point?
Other than to emphasize the point that you just made, no. The worst case scenario, from my perspective, though, is if you've got someone who, in the course of a single year, has received both a W-2 and a 1099 from you. Even if you jump through some of the other hoops, you are starting 3 stories below ground to dig yourself up to a level playing field if you get audited in such a situation.
Yes, it's it's very hard to play catch up in these scenarios, and one of the things that I would strongly counsel people to do if you do get audited. These are not surprise raids by the INS or ICE. These are letters that you get in advance requesting you for information. And you've got time, and they're usually quite respectful of your time. And I can't emphasize enough that you should prepare for these audits like it was a final exam, because that's really what it's about. If you prepare it well enough, then the likelihood of your doing better in the audit is greatly enhanced. If you think of yourself as the auditor for a moment, and you come in and things are disheveled and files are not organized, you're going to think that either the engaging entity doesn't care, they don't know their business very well, or they're trying to hide something. That's the typical presumption of these auditors. On the other hand, if you're well prepared, you have the files organized, and by that I mean basically down one side of a conference room table you have your employees, and you can show payroll files, W-2 forms, personnel files, employment applications, and all those things organized. And on the other side of the conference room table you have all your contractor relationships, including your engagement agreement, your invoices, the business cards of these individuals, and other indicia of arm's length relationship. Then you're going to have a fairly structured and organized conversation, and the auditor is going to go, well, I'm going to go to the organization down the street that's undialed where the fruit is hanging lower to the ground. Then after this, then this organization that obviously has got it organized and has thought this through. It also prepares one better to answer the questions the auditor is going to ask, because as you can see, it's one of the situations where they know all the rules to the game and you don't, and they've already presumed your guilt, and you're trying to convince them otherwise. So I can't emphasize enough that being prepared for these audits is absolutely critical if you find out one is going to happen to you. So here are some action steps that we are going to recommend before we take questions. And the first one really is to conduct a pre-audit. And we have these mini audit available, and we will be happy to send that. Next, screen and communicate the risks to contractors. I had a situation early in my career where there was a piece of tax legislation the Tax Reform Act of 1986 that required the conversion of my clients of hundreds of contractors to employees because they were legislated out of existence. And these were computer contractors and programmers. And I had to talk to these contractors. And these people were what I would call conscientious tax objectors, many of them. They did not, many of them didn't even want to live in the United States, and others certainly didn't want to pay taxes. And so it was very difficult to convert them over to employment status. If interviewed in an audit, these individuals would not do well. So you really want to talk to your contractors and know who they are, and know that if this relationship were ever questioned, how would they communicate this? That's sort of a subtle factor that you need to think about because it may be tested. Track and monitor relationships separately. This has to do with the permanency of the relationship and the term of not a labor contract, but of a contractor agreement. In other words, are you tracking these terms? Is it one of these contracts that just goes on without end, or is there a term, and is it renegotiated? For long-term contractor relationships, that's one of the factors they look at very carefully. Is it just some letter that these guys wrote 10 years ago? Because the longer the relationship, the more permanent the relationship, the more integral to the business, the more it looks like an employee. So if it's going to be a contractor relationship, they like to see fixed-term contracts that are renegotiated with rates changed and terms changed and that are negotiated at arm's length. So we recommend tracking and monitoring these carefully. Make the conversions from contractor to employee at year-end. And this is the point that Eli brought up a moment ago. If you're going to have somebody who is a W-2 employee convert to a contractor, the best time to do it is year-end because they look, when you're auditing, they look tax year to tax year. And if Joe Jones got a W-2 in 2010, and now Joe Jones, because he hasn't incorporated, is a contractor in 2011, that's going to be better than if they got both a W-2 and a 1099 the same tax year.
Exactly. and then lastly, convince as many of your contractors to be corporations for the reasons I stated earlier. If they can incorporate, that goes about 95 yards down the playing field from an auditor's perspective, that they've made a commitment to being a standalone arm's length business, that they're paying their required corporate taxes every year, they're filing a corporate return, they've probably got their own corporate benefit plans. Those are really good facts when you're trying to distinguish them from employment status. So this next slide, I just wanted to show you on our system a little tool that we track contractors as well as provide employment information and HRIS tracking. But this is just a sample of the kinds of things that you ought to track and have for your contractors, such that you can show them on the right side of the conference room table as opposed to employees on the left side. So with that, let's move to our question and answer period.
Okay.
Marianne, did we receive any during the...
Yeah, we have a few questions. As a reminder to everyone else, if you do have questions, please go ahead and type them into that questions box. We'll take some now, and if we run out of time, we will get back to you privately after the webinar. So the first question is, could you give some examples of common contractor relationships that would stand up in the design, architecture, engineering industry? Like, what are some common ones?
Yeah, I'll step in on this one, Paul. I think the types of independent contractor relationships that are really safe and solid in the A&E industry are where you actually are subcontracting with someone on a project for a skill or a type of expertise that you do not have internally. For example, you may be the lead architect on a project, but you have no expertise in seismic engineering, and that is something that is necessary for the project, or landscape architecture. You have no one internally who does that. So you sub with an organization that does have that level of expertise. Those are classic. Everybody's seen them, everybody's used them, and they are very safe.
Okay, great.
Yes,
so,
another example. Another example. Can you hear me?
Yes.
Marianne?
Yes, absolutely.
Are you there? One other example that might be used, or well, let me do it conversely. One of the worst case scenarios would be somebody who worked in your firm prior to the economic downturn that was laid off, that you didn't have enough work for, and now subsequently a new project came in, and you'd like to bring this person on board, but you're not sure if there's going to be enough work to really re-employ them, so you're just going to do it the easy way using a 1099. That is probably the worst scenario by contrast, because it will likely not fly. And what I tell my clients is that may seem expeditious in the near term, and it may look like you have better margins because you're not including this individual on benefits or making the commitment to them as an employee. But down the road, 2 years from now, when you get audited, and the typical EDD audit goes back 3 years, I might add, that you may find out that there's liability there, and the margin you thought you made on this particular project is going to be evaporated and then some.
Yeah, exactly.
So just want to use that as a contrast to your example, Eli. Sorry, Marianne, go ahead.
Oh, that's fine. Okay, so how do you recommend going about convincing, you mentioned a couple of times throughout the presentation that sometimes it's difficult to convince an independent contractor that they really ought to be a W-2 employee. Do you have any recommendations for how to approach that?
I do, having done a bunch of this, and Eli, please jump in, but my experience is I do a little Excel model and show them the cost of employment versus the cost of contracting, because there's a couple of issues. First, from a philosophical standpoint, they do not want to be audited any more than you do, because what happens is when somebody who is a let's just say new contractor and doesn't really have a long-standing business, the typical thing that I see happening is they take all their buddies to dinner, they fully deduct their car, they deduct a portion of their home as their office, they come up with a lot more deductions that are far more aggressive than any business person would normally deduct, and then they put those in on their tax return. Well, if the contractor relationship gets disrupted, then so do all those deductions, because if it turns out they were really an employee, then none of the deductions hold. And during the same period of the audit, they're going to have to go back and pay more taxes. So that's one very key argument that does get their attention. Because, of course, you don't know what they're deducting, but I can tell you from my experience, it's usually much more aggressive than you would imagine. That's one of them. Secondly, then it becomes, well, what do you pay them? So if you were paying them $90 an hour as a contractor, and you have to bring them inside on an hourly basis or on a temporary part-time basis, how do you make that conversion? How do you convince them that they're going to get paid less now because there are all these additional costs of employment that are involved? And that's where the spreadsheet comes in, to kind of show them that, well, there's this much for benefits, and there's this much for matching taxes, and there's this much for San Francisco payroll tax, and there's this much for healthy San Francisco, and all the other things that come into play. So that would be how I would approach it. And the best way, of course, to do it is on the front end before you have a relationship, not convince them, not have to talk to them after you've already got a contractor relationship that you don't think you can defend.
One other thing that I do, and it is part of the written agreement with the person, is if they are or the entity, if they are insistent that they be an independent contractor as opposed to an employee as you would like them to be, then you build into the contract that if something goes wrong, if they're found to be an employee, then they have to indemnify you for any liability that results. To be perfectly frank, those indemnification clauses probably are not fully enforceable, but they at least tell the person who wants to be an independent contractor, put your money where your mouth is if that's what you want to do.
All right, that's interesting. Have a somewhat specific question. What about independent contractors who are getting paid an hourly rate? So what would you do about time cards, and does that, cloud the independent contractor relationship?
The hourly paid independent contractors are probably the lowest of the hanging fruit. And you often have an independent contractor who's on a time and materials basis, and they will be telling you, reporting the hours. That is not my favored approach. The best approach is you've got someone who bids on a project, and you pay them based on the project, or you pay them a fixed rate for different time increments. But that said, you can have legitimate independent contractors who are billing you on a time and materials basis and basically being paid hourly.
A corollary to that is, and this is what I've seen a lot in preparing for a lot of audits, if you've got contractors using exactly the same timesheet and reporting mechanism that you do employees,
Terrible.
Let's just say that's a bad fact.
Yeah.
Because anything that looks like employee in that contractor file is not going to be good. So at least the contractor ought to be able to aggregate the hours, put that into an invoice form, submit that invoice, and you're paying on an invoice with a number. I mean, you at least have to be able to do that, because if it's, if they're getting paid right off the time card or the timesheet or the electronic system the very same way employees are, that looks terrible.
Yes.
Okay. So how frequently, you mentioned, the duration of an arrangement is sort of, one of the factors in establishing how integrated someone is into your business. How frequently should you be renegotiating your independent contractor agreements?
Well, in my experience, go ahead, Eli.
Yeah, my recommendation is that you renegotiate at least once a year.
Yes, that was going to be the same one that I have. That, if it goes much, and if it goes longer, and these multi-year kinds of contracts, then you're going to really have to show why that is separate. I'll give an example. In one industry I work in the moving and storage industry, it's pretty common to have the mover own the warehouse, do all the sales, do all the administrative side, and then contract out for what they call cartage or the delivery work, so that the individual drivers own their own power equipment. They got an investment in the business. They pull trailers that they lease for a long period of time, and they come to and from the warehouse and make deliveries. And if those distinctions are crystal clear like that, and there's essentially a joint venture business relationship to serve the mutual shipper, that's defensible, and we have defended that many times. It's where those lines get blurred and, oh, the mover has a few trucks. And so there can be long-term relationships, but even in those scenarios, I recommend at least once a year to renegotiate those agreements.
Okay, and
Yeah,
what sort of documentation would you need of the renegotiation? Is that a fresh contract or?
Usually, it would
okay.
be a fresh contract. That's not too hard to create these days.
Yeah.
Great.
And it need not be radically different than the contract before. Just evidence that you have sat down and you've renegotiated terms. You may agree on the majority of them going forward and change some. But that, I think, would be sufficient to indicate that you seriously are looking at the relationship on a regular basis and deciding if it is the terms are appropriate now.
Great. Well, those are most of our questions. It is 10:59, so I believe we're ready to wrap things up here. Did you guys have anything else you'd like to add? Great.
No, we appreciate everybody's time and attention today,
Yes.
and we'll be happy to get back to you if there are specific questions.
Exactly. Thank you
Yes.
very much.
Thank you all for attending, and as you exit the webinar, as a reminder, you will see a survey. We would appreciate your candid feedback. Also, that is where you can indicate if you would like to receive copies of the handouts. So if you could fill that out, we'd appreciate it. Thank you, everyone, for your time and attendance this morning, and if you did have questions that weren't answered, we'll be in touch. Thanks.
Thank you.
Thanks. Bye now.